In the United States, the title of federal judge means a judge nominated by the President of the United States and confirmed by the United States Senate pursuant to the Appointments Clause in Article 2 of the United States Constitution. In addition to the Supreme Court of the United States, whose existence and some aspects of whose jurisdiction are beyond the constitutional power of Congress to alter, Congress has established 13 courts of appeals with appellate jurisdiction over different regions of the United States, and 94 United States district courts. Every judge appointed to such a court may be categorized as a federal judge. Such positions include the Chief Justice and Associate Justices of the Supreme Court, circuit judges of the Courts of Appeals, and district judges of the United States District Courts. All of these judges described thus far are referred to sometimes as Article 3 judges, because they exercise the judicial power vested in the judicial branch of the federal government by Article 3 of the U.S. Constitution. In addition, judges of the Court of International Trade exercise judicial power pursuant to Article 3. Other judges serving in the federal courts, including magistrate judges and bankruptcy judges, are also sometimes referred to as federal judges. However, they are neither appointed by the President nor confirmed by the Senate, and their power derives from Article 1 instead. The primary function of the federal judges is to resolve matters brought before the United States federal courts. Most federal courts in the United States are courts of limited jurisdiction, meaning that they hear only cases for which jurisdiction is authorized by the United States Constitution or federal statutes. However, federal district courts are authorized to hear a wide range of civil and criminal cases. District court judges are recognized as having a certain degree of inherent authority to manage the matters before them, ranging from setting the dates for trials and hearings to holding parties in contempt or otherwise sanctioning them for improper behavior. In other circumstances, their actions are dictated by federal law, the federal rules of procedure, or local rules created by the specific court system itself. Article 3 federal judges serve during good behavior. Judges hold their seats until they resign, die, or are removed from office. Although the legal orthodoxy is that judges cannot be removed from office except by impeachment by the House of Representatives followed by conviction by the Senate. Several legal scholars, including William Rehnquist, C. Krishna Prakash, and Stephen D. Smith, have argued that the Good Behavior Clause may, in theory, permit removal by way of a writ of scire facias filed before a federal court, without resort to impeachment. As of 2019, federal district judges are paid $210,900 a year. Circuit judges $223,700. Associate justices of the Supreme Court $258,900 and the Chief Justice of the United States $270,700. All were permitted to earn a maximum of an additional $21,000 a year for teaching. Chief Justice John Roberts has repeatedly pleaded for an increase in judicial pay, calling the situation a constitutional crisis that threatens to undermine the strength and independence of the federal judiciary. The problem is that the most talented associates at the largest U.S. law firms with judicial clerkship experience already earn as much as a federal judge in their first year as full-time associates. Thus, when those attorneys eventually become experienced partners and reach the stage in life where one would normally consider switching to public service, their interest in joining the judiciary is tempered by the prospect of a giant pay cut back to what they were making 10 to 20 years earlier. One way for attorneys to soften the financial blow is to spend only a few years on the bench and then return to private practice or go into private arbitration. But such turnover creates a risk of a revolving door judiciary subject to regulatory capture. Thus, Chief Justice Roberts has warned that judges are no longer drawn primarily from among the best lawyers in the practicing bar, and if judicial appointment ceases to be the capstone of a distinguished career and instead becomes a stepping stone to a lucrative position in private practice, the framers' goal of a truly independent judiciary will be placed in serious jeopardy. Each Federal judge serves at a particular duty station for the duration of his or her federal service. This is important because of the relationship among several federal statutes. First, 28 U.S.C. Section 456 entitles federal judges to reimbursement of transportation and subsistence expenses incurred while transacting official business away from their duty stations. Section 456 also prescribes that the District of Columbia is the duty station of all members of the U.S. Supreme Court, the D.C. Circuit, the Federal Circuit, and the U.S. Dis.